A very warm good afternoon to all of you. I also welcome our online friends. Today I propose to deliberate the sources of international human rights law, what has been the journey of international human rights law, which movements have empowered the idea of international human rights law or human rights per se, what has been the sources of international human rights law, and at the same time we are going to deliberate, my dear friends, how we have been witnessing an empowerment, a proximal mobility, evolution of a trajectory that is embracing on daily basis certain new sources of international human rights law. What we have initially studied during our graduation days, so far the sources of international human rights law are concerned, that visage has already changed. It has also acquired the new dimensions, new delineations, and new dynamics, which have established themselves as the new and novel sources of international human rights law. My dear friends, when we talk of sources, it means we are talking that we are tracing, deriving, stemming, or tracing the genesis and roots of something, and in this case it is the human rights. I understand that you have already studied the sources of international law, but so far the sources of international human rights law is concerned, not only we are supposed to undertake the sources of international law and try to evaluate the dimensions with which we are going to cajole, we are going to trace, and we are going to find out that these are the sources of international human rights law emanated from the sources of international law. But before I proceed further, there are again certain important questions with regard to the sources of international human rights law, and these sources must also be appreciated in the light of these questions. What is the legal nature of human rights obligations, and who is bound by human rights obligations? Then here the question arises with regard to sources. Should we treat in international human rights obligations as the sources of international human rights law? If yes, then what are the limitations? What are the luxuries? What are the laxities which are available in this particular dimension? What are the limitations? To what extent we can consider that sources of international human rights law obligations, or to what extent these obligations are going to be treated or construed as the sources of international human rights law? That should also be taken into consideration, because the obligations of human rights or human rights obligations are nothing but the constitutional law obligations emanating from our respective constitutional jurisprudence, as well as the constitutionalism that has been treated as well as strengthened by the judicial establishments or highest judicial establishments and the writings of the jurists or constitutionalists. So this is how we should try to understand this entire what we call obligation trajectory. There are, some other, other questions as well. How was international law applied through the end of the Second World War? What limits do human rights impose on states combating terrorism, drug trafficking, and other important, what we call, issues of an international, character, or other kinds of, challenges with which the international community is grappling with? Should states promote international justice for human rights violations? What role do the legislative, judicial, and executive actions of states play in the promotion and observance of, human rights? How has the spread of liberal constitutionalism helped these, what we call, efforts? And to what extent the liberal, what we call, constitutionalism should be construed as one of the sources of international human rights law? I am not here to talk what we have already studied in our graduation days so far the sources of international law is concerned. We have to, look beyond this traditional conventional prism of, sources of international law. We have to look beyond. We have to review what are the formal sources and what are the informal sources of international human rights law. And my dear friends, the very first, source that it starts, with which we try to, start our entire, what we call, deliberation, is the human being per se, human being itself. When we are, talking of human rights, and simple question we are, putting in public domain, and that is, what is the source of, human right? If Sumaya Islam is asking this question to me, then my answer would be that you are the source of law, Sumaya. You yourself is the source of, human rights. If our online friends, suppose Miss Wasaf Rasool is, asking this question, who is the source of, international human rights law, then Wasaf Rasool herself, she happens to be the source of, human rights. So this is how we should begin. I should not simply say that this is the, international treaties, customs, they are the, sources. Juristic writings constitute as one of the, sources of international law. United Nations, resolutions, they are the, sources of international law. But the basic and the most fundamental, rudimentary source of human rights begins with the birth of an individual, because an individual is also the source of law, source of human rights. So this is how we should, try to understand this entire, what we call, gyrational, rotational, and notional, trajectory of understanding human rights. You have studied each and everything so far the, sources of international law is concerned, or international human rights law is concerned. There are plenty of, what we call, books in the public domain, plenty of research articles are, there. But as a part of the, higher education trajectory, as a part of this particular, higher education compendium, we are supposed to understand and take into account some unconventional, understandings, non-traditional, understandings so far the sources of human rights is concerned. International law per se is the source of international human rights law. International humanitarian law is the source of international human rights law. International refugee law is the source of international human rights law. International criminal law is the source of international human rights law. International constitutional law is the source of international human rights law. And my subsequent argument will definitely, crystallize it. My dear friends, if we are confronted collectively with any kind of a, human rights violation, and we are demanding the redressal of that particular, human rights violation, under the 9 core human rights, treaties which have been adopted under the auspices of the United Nations organization, then in such a situation, if we find that resolution of our human rights grievances are not possible, or a particular individual grievance cannot be redressed by applying the 9 core international human rights treaties in that particular scenario, in that particular context. What are the remedies? What are the resolutions? What are the palliations which are available at our disposal? That is the basic and the most fundamental question. Because when we are talking of the 9 core international human rights treaties, we are simply talking about the subject matter of international human rights law. That is why, my dear friends, we require a multi-dimensional approach, an interdisciplinary approach, a human rights based approach, a teleological treatment of human rights that becomes germane in this particular, an epistemological understanding of human rights becomes imperative in this particular, context. That is why we require that we should not look so far the sources of international human rights law are concerned. Even the First World War, Second World War, interwar minority regimes, they also constitute the sources of international law. Even, movements, civil society movements, Long March in Pakistan, peasantry movements in India, social movements in Bangladesh, recently concluded movements for the change of guard at the Rashtrapati Bhavan of Colombo. That is basically these kinds of movements constitute the sources of international human rights law, because human beings are involved, their dignity is involved, their collective conscience is involved, their individual rights of a political and civil nature are involved. Even first generation human rights, second generation of human rights, third generation of human rights, and the latest one, the fourth generation that is emerging there. I mean, under this particular, generation, there are certain important rights which also constitute the sources of international human rights law. That is why I have said, my dear friends, that the international humanitarian law is the source of international human rights law. International criminal law, exclusively based on the principle, whatever the principles have been agreed upon in the schematization of the Rome Statute of 1998, that constitute one of the sources of international human rights law. So sources are there. What is important is sometimes we create the categorization, departmentalization of sources, classification of sources into different categorizations, like the formal sources of international human rights law and the informal sources of international human rights law. But what is important is that the sources are everywhere, and that is why we try to appreciate the nature of human rights, availability of human rights, accessibility to human rights, affordability of human rights, and above all, the enjoyment of human rights, by taking into consideration, as a researcher, as a critical thinker, only one framework, only in one direction, only taking into consideration a specific methodology as a framework to understand and appreciate the idea of human right. Suppose a sociologist is appreciating the idea of free speech, a historicist is evaluating the idea of what he call of free speech. An individual who comes from the capitalism kind of what he call environment, he is also having his take on the idea of right to free speech. So see how many frameworks different individuals are undertaking to understand only one goal, and that is idea of free speech. To me, free speech is something different. I am having a different kind of a framework to appreciate on critical footings, on the anvil of what we call this framework. I am evaluating the idea of free speech. Maharajan is having a Dalit framework to understand the idea of free speech. He is having, or work-based, as our scholar, another your senior PhD student, Mr. Bhimraj, he has taken a different kind of framework to understand the idea or the right to work. He has taken the idea of decent, origin, birth, and on the basis of that particular criteria, he is inventing. He is having some kind of a theoretical construct that this is how we should try to appreciate the idea of right to work. A communitarian approach has been adopted. The idea of collective consciousness is reflected in that particular framework. So it depends on what kind of ideology, what kind of approach we are going to adopt. Everybody is talking of the right to free speech. Your idea of free speech is different. Your idea of free speech is different. He is having a different kind of idea of free speech. But that idea of free speech is available in the scheme of the our respective jurisdictions, our respective constitutions. But we have to casual, we have to understand. So there is, my dear friends, this is something which I am sharing on the basis of my experience as a student of international human rights law, that we cannot clubbed the sources of international law in this kind of fragmentations. Different every if we are going to adopt some kind of a fragmentary approach, each and every fragment is having some kind of history, some kind of a genesis, and it derives its authority from that particular ideology. We should not, I am not here to indoctrinate you that this particular framework, this particular ideology, this ideological framework, this ideological methodology is going to be suffice. No, you have to test your hypothesis on each and every aspect of a particular ideology. Because this reminds me of a very, very famous what you call dictum of Edmund Burke: small minds and big empires cannot go together. So we are in higher education, my dear friends. We have to leave for a while our ideological affiliations and ideological what we call background and entire what we call understanding of ideologies. Then only we are going to be in a better position to appreciate that this is the human right, and this is the so you can visit the idea of right to free speech while undertaking a journey which is having some kind of a historical approach, sociological approach, or other kinds of, or a Marxist what he call framework of right to free speech, or a capitalist orientation of what he call free speech. Are you getting this entire what we call debate? So this is how we should try to understand the sources of international human rights law. I simply, and you should, this is my sincere advice to all of you, whenever you face or confront any kind of a question of this character in your ensuing midterm examination, you should not what we call reproduce what you have studied in different what we call test books as well as the reference books. Rather, you should come out with your own understanding. And a person like me, I am here to appreciate your independent individual contributions that must be reflected in your answers. So your entire orientation, your presentation, diction, that must be what we call distinct and independent. You should not subscribe to any kind of what we call copy pasting, or copying something and cutting and thereafter pasting it, because this is something I have already identified when I applied softwares to your answer sheets. But because of the extraordinary circumstances, we collectively what we call taken a very liberal view and we avoid it. So please, because there are decisions from the Indian High Court, so particularly let me make a reference of the Bombay High Court. In one of the decisions of the Bombay High Court, it has been observed by the bench of the Justice Desai that memorization and the reproduction thereof in the answer sheets amounts to copying. But you may differ because we are in higher education. So that is subject to judicial scrutiny, because even memorization is equally important. There are people who cannot memorize. People like me, I cannot memorize. So It is very difficult even to 3 or 4 sentences at least I cannot memorize. So with this, understanding, let me take you to another important what we call, understanding of what we call of, human rights. That is equally important, and that should also be taken into consideration, because there are, certain important, timelines, and those timelines must also be, understood in the right kind of a, perspective. And that timeline also poses, suppose there is a timeline so far the evolution of human rights is concerned, then a list is, before me, but I would be, sharing by an email. But one of the most important idea that I would like to share with you is that is there Hammurabi, or you may also call it the Babylonian Code. In this particular, code, we find as many as 282 laws. Please do not write, Mr. Sagar. That is your property, which is before me. I will share everything. Try to understand. You are no more kids, and I'm not dictating or, delivering some kind of a dictation, and you have to jot it down. It was for the first time, and you might have, heard, so far the wisdom of the United India is concerned, when there was no Bangladesh, no Pakistan. And during the Mughal period, Jahangir is known as, so far the justice of Jahangir is concerned, eye for an eye, hand for an hand. That sort of what we call, justice system or principle was adopted by King, Jahangir during his, regime in India. Basically, this entire idea was, taken from Hammurabi Code. It was not the creation of the Mughal what we call justice system. We find this kind of a, justice for the first time. It was, there, and Hammurabi Code, my dear friends, was, if you take into account the period, it was, 1792 to 1750 BC. During that particular, time frame, Hammurabi Code came into existence, and one of the laws out of 282, laws, it was, so far the justice system was, concerned in terms of, a punishment or punishments. It was basically based on an eye for an eye, a tooth for a tooth. That is the, words which have been, used. So, and there have been even the, there is a, another important religious scripture which is subsequently known as the 10 Commandments. And there is a movie with the same what we call, name, and it is a movie on Prophet Moses. So the Prophet Moses, peace be upon him, he came out with this particular, idea of what we call of, justice and the what we call, human rights. Then in the secular world, my dear friends, I am not what we call, I am not here to be there each and everything for your consumption from the, this entire list which I have, prepared. But for your academic purposes, you should try to study this entire timeline in due course of time. Within this week, I am going to share this. Yes, ma'am.
The 10 Commandments are duties, not rights.
Before your arrival, I have said something. That is why punctuality is important. Right? And the punctuality demands that you should not miss my submissions. When I start, everybody should be there in the class. I was talking of approaches, I was talking of ideologies, I was talking of frameworks, I was talking of informal sources, I was talking of formal sources of law. That is why it becomes. Because if you are saying something like duty, so it is susceptible to various interpretations. If I am talking of rights, fundamental rights under the Nepal's constitution, then even the Nepalis are more comfortable so far their interpretation is concerned. What is a duty to me or to you? There is every possibility that subsequently it may be construed as a right. You are saying it is not a right, it is a duty. There are people who are saying that these are the what we call governance principles. Suppose, let me give you an example from the Constitution itself. You are from India. Take the example of the part 4 to the Constitution of India, Directive Principles of State Policies. If you apply the yardstick of interpretation, then linguistically speaking, ideologically speaking, I find in my individual capacity, my statement should not be taken as some kind of a gospel gratification or some kind of idea of constitution. No. You got every right to disagree with me, and my submission is it starts with directive principles of state policy. What does it mean? How do you interpret it? Though it has already been ordained that these are non-justiciable rights or principles. I cannot bring any kind of invoke these before a court of law for their implementation. But if you see the interpretation, the judicial interpretation or the adjudicatory jurisprudence that has been produced by the Supreme Court of India under Article 21, we find on different occasions in the evolution or in the empowerment of the human rights, the Supreme Court of India has adopted a novel technique, lifting directive principles of state policies and placing them and grafting them within the systematization of the part of the Constitution of India. What was non-justiciable earlier has become justiciable. So, but even without doing or adopting this kind of a technique, as a student of interpretation of the statutes and legislation, this is my well-considered opinion, ma'am, that it starts directive principles, then define the word directive. What does it convey? Directive means
Guidelines.
not guidelines. Directive, the word per se demands compliance. The word directive demands. It ensures that there should be some kind of execution, enforcement, implementation, whatever has been ordered or emanated from the higher authority. Yes, we have, the government of India has issued a directive. Guidelines is some kind of a soft law. So far, my understanding, you can correct me. I'm not making some kind of a compulsory statement or some kind of a making sweeping remark. No, that is not my intention. Then the directive principles. I will come to again from the international law also. I will give you an example. Principles are there. It means there are certain important norms, and these principles are also available from Article 1 to Article 5 of United Nations Charter, purposes and principles of this multilateral organization called UNO. Again, of directive principle of state policy. Policy is a dangerous what we call premise. I do not like, because policy is always volatile. There is no certainty. We do not find in the area of policy some kind of a certificate. What may be a policy today, it may not be there tomorrow. There are certain important words. That is why I would like to make a recommendation at this stage on public policy, try to understand what body Ihrl has offered in his jurisprudence. Because public policy, public interest, national interest, social interest, these are some of the important words. And these are the humongous words, vacuous words, but full of vagueness, full of volatility. There is no certainty. That is why, instead of policy, it is the legislation that has been regarded as the strongest resource of law. So when we are saying directive principles of state policy, it means there are certain important constitutional principles in each and every what we call constitution of South Asia, which must be reflected in the governance architecture and the governance priorities of the government of the day. But instead of this, we are having the idea of Sankalpa Patra in India or election manifestos. That is the reason. Again, let me take an example. I am coming to you from international law. People generally say that the Universal Declaration of Human Rights is a soft law. It is a very subjective line of argument. Yes, it was, it has been a correct what we call premise, but at the initial stage. When we have witnessed development, many developments, and people today are asking questions. Yesterday, even in University of Oxford, there was a debate, and in this debate, they have raised the question: what is the future of international law in the next 100 years? Should I, subscribe? Try to understand. I will give you the link. Don't worry. You immediately started cooking. What is the future of Universal Declaration of Human Rights, and what would be the future of Universal Declaration of Human Rights in the next 100 years? Or what would be the future of the four Geneva Conventions of 1949, which constitute the subject matter of IHL, with their 2 additional protocols? This is the question. Today I can say, yes, on 10th of December in 1948, Universal Declaration of Human Rights was a soft law, a non-justiciable premise. It was something like a kind of a political compromise. Because the 2 important ideological streams have been amalgamated and placed under one what we call, umbrella. And it has been nomenclatured as Universal Declaration of Human Rights. It is a development that was earlier also, taken place. Took place in 1215 when the Magna Carta was adopted. But what has been the fate of the Magna Carta? The question must be asked about the implementation, execution of the various provisions, particularly the provisions relating to discrimination and provisions relating to what we call, arrest and accountability under Magna Carta. Section 36, 37, 38, and 35. If you take into account collectively these sections of Magna Carta, you will find that it was purely a political, compromise, and the King John turned out to be, after, putting under pressure, putting his signature on this, document, he turned out to be a monster. He started killing those people who ultimately compelled him to put his, seal and signature. So subsequent developments are equally important. The point which I am making, Miss Yodha, is that Universal Declaration of Human Rights today cannot be categorized as non-justiciable. Yes, it is non-negotiable. It remains non-negotiable. Because when Universal Declaration of Human Rights is put along what we call 2 other important, covenants, it constitutes and it becomes the International Bill of Human Rights. So by implication, we can implement it. Because when we are, talking of the 3 important documents, UN Covenant on Civil and Political Rights of 1966 and UN Covenant on Economic, Social and Cultural Rights in 1966, along with the Universal Declaration of Human Rights, these trinity of human rights document, this trinity does not create any kind of a trichotomy. It does not create any kind of a dichotomy. It basically creates a confluence, a roadmap, a guideline for the implementation, realization, and execution of idea of international human rights law. So by way of implication, and this particular argument has become more strengthened ever since the recognition of an individual as a subject matter of international law. And this is a development, my dear friends, which took place in the later half of the 20th century. When idea of another important development has also taken place, and it is basically the crumbling down or the dilution of the national boundaries. Today, we cannot say that the national boundaries commands, despite the fact, my dear friends, and currently I am working on this particular aspect, the emergence of the border walls, the border justice we are talking of, or the frontier justice we are talking of, and there is a what we call fashion, whether it is Turkey, whether it is Israel, whether it is what we call US, Mexico, everywhere we are witnessing the new kind of development, just to save and just to preserve their idea of what we call or maintaining the virginity of their what we call sovereignty. So they are constructing walls, but that is a violation of the customary international law. So that is the point. So whether it is the directive principles of state policies in the context of India, or whether it is the Universal Declaration of Human Rights in the context of international law, I find, and I should say, that these are no more the soft laws. They have attained implementability. They have attained some kind of robustness, some kind of executionary what we call bill, and we must execute them. So after 100 years, after 50 years, or in the next what we call or 100 years, we should try to what we call locate. If suppose generally, even your parents, your friends, they also ask you, yes, Miss Pandit, where do you see after 10 years or 5 years? So far your career is concerned. So far your options are concerned. Where do you find yourself after a gap of almost 10 years from now? These are the general questions. We put ourselves. Suppose my wife was asking me a question, where do you see at the age of 60? Then I simply said, yes, I would like to enjoy a cup of tea over a roadside eatery, free from all kinds of encumbrances, or free from all kinds of liabilities. So it is basically it is basically a question of what we call our intellectual evolution, how we have been evolving. So definitely, if today we are making some kind of constitution, if today we are entering into some kind of what we call constitution, or we are going to draft something, everything cannot be incorporated. Same is the case with that of the Universal Declaration of Human Rights, my dear friends. It provides only the substantive normative understanding of certain important rights, collective rights as well as the individual rights. It's the amalgamation of two. As I have already submitted in my earlier submissions, if you try to consider Article 1 and 4 to what you call Article 22, you will find civil and political rights, what we call treatment under UPHR. And from Article 23 up to Article 30, you will find a communist or Marxist orientation of rights, where you will find community, communitarianism, collectivism, or common rights, societal rights, groups rights. These are the rights which have not been branded as rights so far the advocates of the civil political rights hailing from the global north jurisdictions are concerned. So they are having a different kind of a take so far these rights are concerned. Yes, now I invite your intervention.
I was trying to say that the example that you give of I think what I was trying to say that 10 commandments for duties in sense they were kind of telling like thou shalt not speak, thou shalt not indulge in adultery, and so on and so forth. And so the more the better analogy would have been the Article 51A, which is duties, fundamental duties. So if you take the talk of directive principles, they may be non-justiciable, but they can still be considered rights in some sense. But when you're talking about 10 commandments or fundamental duties, they are duties. I don't know how can we see them as rights.
As a researcher, it is a stage where this stage demands that we have to think not as a student. We have to think as a researcher. You take only one tablet from the 12 tablets or 12 tables, which are inscribed on stones by Prophet Moses, peace be upon him. So if you take into account one particular, table, or the commands which have been what we call, given, because that is why we call them the 10 commands. And I'm not the first one who is, attributing with this kind of, terminology. Idea is that if a state, empowering, suppose the constitution is empowering citizens, providing certain important rights. So it becomes the commands and rights on the part of what we call, state, but presented as duties to the masses, to the, citizens. So when we are going to evaluate under a framework of understanding, when we are researching on particular, dimensions and aspects, then this becomes the rights of what we call, of, God, and he's, demanding. And at the same time, if you are evaluating, suppose subsequently, I am having this a very, very elaborate, discussion in the context of a universal declaration of human rights. But these, 10 commandments have also been presented as, duties, but should be, performed as a, right. Suppose one article of the Universal Declaration of Human Rights simply right to what we call, have, or right to leave your own country. Suppose if you take into account Article 15, Article 14, right to asylum and enjoyment of asylum in another country or protection in another country. Article 14 of the Universal Declaration of Human Rights. Here, very basic and fundamental question arises. You have also raised it. Is it the right of the individual to seek what we call, asylum in another country? Or is it a right of the state to deny that we are not in a position to entertain you in our territory? We cannot grant you. So how to reconcile? This is a debate. Similar is the case with that of to what extent, what is the extent, what is the province, what is the, the circumference within which we can what we call, exercise these, 10 commandments as duties or 10 commandments as rights. It is a question of what we call at this stage. As a researcher, we have to contemplate, we have to think. We are not the ordinary what we call students of BLLB program. It's a research program. So research orientation of deliberations, and I'm not delivering any kind of a lecture. I call it interactions, cross-fertilization of ideas. We are exchanging views. So it is altogether a different story that most of the time I'm speaking. But you are the equal stakeholders. You can also, come out with your own, understanding of this particular point.
But if you say it's a hard lobby, what is the enforcement mechanism? If you say that the GHR and the
Yeah, please, I draw your attention. You have enjoyed enough outside, so whenever you enter in the class, calmly occupy your seat.
if you say UPHR and the components are hard, as I have learning from that the evolution has taken place and a lot of things have happened. But where is the enforcement mechanism? Because apart from ICJ and
Yeah, very pertinent question. Very, very important question, my dear friends. The implementation, let me tell you. Few people have been set at liberty yesterday. One fellow, because of his just a pitcher, an adram what you call, pot containing water, he has been killed. That is the implementation. And it is not confined, my dear friend, to India alone. Even the atrocities and how particularly the one religion, and that is Hinduism, is persecuted in Pakistan. There are, instances how what you call, political opinion is subjected to some kind of a torture in Bangladesh. How the social origins are, treated in India. How minorities are treated in India. Everywhere It is not a question of religion. Two important, what you call, criteria, two important grounds should always be the subject matter of the subject matter, so far the testing of human rights, sincerity of the availability of human rights, and the sincerity should be replaced with the word dignity of human rights. It is basically the two important casualties I find as a student of international human rights law in response to your argument: political opinion and social origins. I am having a larger, what you call, perspective. I am not, what you call, simply confining my argument to religion. No, it is basically the ethnicity. It is basically the social origin. And in the context of, South Asia, there are two important, factors. One is class, and another one is caste. Where the caste has been, diminished in certain important, societies, then instead of, caste, it is the class. There, in the context of what we call of some of the, elite people, in the context of, I'm simply sharing my own experience, and that is from, Muslim community. Whether it is the Muslim communities in Pakistan or what we call, in India. It is basically the idea which is exclusively based on the caste and capitalism cannot go together. So, if you are, let me give you another important, example from, Mewat region, again from, state of Haryana in the Indian context. My dear friends, almost, 10 or 15 years back, one professor from Jawaharlal Nehru University, Professor Imtiaz Ahmed, who recently retired from the Department of Sociology, he conducted a research on the caste, what he called, stratification, on social stratification. There are, very many important, sociologists in India as well, like, Professor Imtiaz, Professor Dipankar Gupta, Professor T.K. Uman. There, I mean, if you try to study their, what he call, contributions, you will realize. Then he visited the Mewat region, which is predominantly a Muslim majority, what he call, a region in Haryana. And he put a question to a peasant, to a farmer: what is your caste? Very blatant and blunt question. What is your caste? Then he retorted back: if my crop this time is going to be excellent, then I am Sayyid. If I am, going to earn something and my produce is something in between, very moderate kind of, earning is there, then I am Pathan. And then if I remain hand to mouth, then I am Ansari. So see the economics of, caste. So this is how even the enjoyment of human rights is also, determined. And that is why, my dear friends, at the very outset of my, submissions, when I was making the overview or making a presentation of the overview of this, course structure, I also, mentioned, I think in second, what we call, submission, I mentioned that the global North jurisdictions do not consider economic, social, and cultural rights as rights. They simply confined the idea of right to civil and political rights, the first generations of rights. Otherwise, they are of the view that economic, social, and cultural rights are not rights, but they are goals, cultural goals, economic goals, social goals. They are not rights. So that is the, controversy. And it is, if you want to be a researcher, we require controversies in higher education. Because that is the bread and butter. This is how we are going to survive. And since you are doing your LLM, then this is my presumption, a very legitimate presumption, that teaching is one of the options for you. That is why you are in higher education. Am I wrong? Yes, ma'am. You are fine. You laughed a lot. Even yesterday's introduction, program. Yeah. So any other observation, any other question? Yes. Shivan. Your name is Shivan. Yes.
I wanted to ask last time we ran out of time.
Yeah.
Since we have discussed a lot of about human rights, what is human rights and this and that. So should we not ask this question that why do human rights exist? Like, are they given to humans for a reason? That's my first question.
Okay. Your question, as I understood, is the very first question, initial one, who is a human? Then the second question comes, and the second question is, what is human right or what are human rights? Third question is, as a human, do I require some rights or human rights? So the very first question, let me come out with this observation. Who is a human? Is it a skeleton who is standing in the vertical form, consisting of hundreds and hundreds of bones? Or when it is covered and encapsulated with the skin, and certain important organs are implanted and made operational, should we confine up to that particular level? That should be the extent to define a human. That is not sufficient. The idea is, my dear friends, a human, when it is addressed as what we call as per the Islamic traditions, and this is addressed as Ashraful Makhluqat, it means a being, a creativity with what we call the art of thinking. When the faculty of reason is implanted in a human being, he becomes a human. For the first time, this question, similar question, my dear friends, and it's a coincidence. And I will share those what we call unstructured writings in my handwriting. I could not find time to what we call to write them or type them. I will definitely show that particular script of my handwriting. It was a question which I have posed to Justice P.R. Krishna Ihrl, what we call column, published in the Hindu. So I raised this question. And I written a very what we call detailed letter to Justice P.R. Krishna Ihrl, because there are some judges who are very close to my heart. I really what we call became like Ihrl, and they have been what we call not Guru Dronacharya. If I take the Hindu mythology, because the future Dronacharya, the due apology has done. Yeah, I should not. I should confine my. So because I cannot demand something from my students in the name of instruction. No. So that is not my idea. Because I am here to share. I am here to give something. I am not here to take something out of you in terms of what we call tangible items or in terms of the material what we call items. No. So that particular idea, that particular understanding constitutes a human. We have to look beyond blood, beyond bones, beyond what we call skin, beyond other kinds of coverings. What is important is the faculty of juridical proclamation. The faculty or the capacity to entertain intellectual dissections. The idea of teleological autopsy. So these are the items, these are the elements which constitute a human. And that is why when the faculty of reason is there, when the faculty of rationality is there, then definitely a human becomes what we call a talking machine. He asks what we call questions. And that is the danger. in the another important world, the world of artificial intelligence, where the human intelligence has been surpassed, and it is basically the machine intelligence, the programmed intelligence, and in other words, cumulatively we call them as artificial intelligence or robotic intelligence. But there are certain important limitations as well. And these limitations have been created in the name of regulations, in the name of human coexistence, in the name of what we call of law and order, public morality, and respecting the rights of others as well. And there should not be any kind of othering, because othering of human beings in the name of human rights is a violation of human rights. Because when we are having or understanding this word called othering, it is basically an idea of discrimination. Non-discrimination is the soul, my dear friends. It is the cardinal principle of the enjoyment of human rights. So the faculty of reason impels, spontaneously impels to put questions, and that makes a human. When that faculty of understanding, faculty of reason is educated, educated means well educated. It does, because people are there. People are there who should be what you call it. And you might have experienced that the people who claim themselves educated but subsequently they turn out to be ill-educated. That is why I'm prefixing the word educated with an adjective called well and well educated. So well educated people, there are well educated people, there are ill-educated people. Despite all kinds of exposures, experiences, age, everything available to them, and they have incorporated everything as an essential part of their what we call personality. They are committing wrongs. They are what we call adopted the wrong attitudes. They are what we call suffering from some kind of intellectual disorder, like commenting on the women's sartorial statements, not what we call paying adequate respect to the modesty of a woman on the world. So different kind of attitudes are prevailing. So idea is, my dear friends, a reasoned faculty of understanding. If somebody is espousing, then only he can claim himself to be a man of what we call dignity, because dignity is something, it is spontaneous, what we call inbuilt, inherent in a human being, but at the same time, if it is there, he will also respect and extend the same amount of what we call dignity to other what we call people. Yes, sir.
What about the non-workers?
Yes, they have been. This is the new kind of a nomenclature in the area of international human rights law, that disabled people are not a disabled people. They are differently abled people. They are mentally challenged people in case of any kind of a retardation. So that is the new. A wife should not be addressed as wife. So far, lexicon or entire lexicological framing of international human rights law is concerned, a wife is never addressed as wife, rather a homemaker. So these are the new kind of terminologies, and this is my submission to all of you, that you should also acquaint yourself with this kind of a lexicon, a lexicon of human rights. But you can also further lexicograph as well. Any other observation? Yes, Miss Vasaf.
Sir, actually, your voice becomes really blur when you go little away. And I can't hear the questions that students ask.
Oh, so I will have to stick to laptop.
Yes,
Yes.
sir. Yes, sir.
So when you are coming to India,
Sir,
will it be
as of
possible in the
now,
next month?
yes, sir. Probably early September.
Inshallah.
Yes. So otherwise, I'm just I'm okay with whatever I'm listening, and I'm okay with whatever materials professors share, because it's really hard to concentrate. Sometimes I can't
Okay.
hear professors, and sometimes I can't hear what students are saying in their comments. In fact, most of the times I'm unable to
Okay,
engage.
I will, I will, spend my significant amount of time before the laptop. I would not be, going here and there. So I should, confine. So
Thank you, sir.
right to movement, I will curtail myself. Yes.
Thank you, sir.
Yeah. Thank you. So that is the right which I'm not going to enjoy. Anyway, well, yes, brother. Your name? Yeah, Mr. Shivam is making a point, Miss, Wasaf Rasool and others on who are available on. Yeah, definitely. She should also, listen, because she is not able to grasp what exactly we are, deliberating if I am away from my laptop. So I become inaudible to them. Yeah. Yeah. Okay. So I will procure. I will ask. Yeah. Bluetooth. Yeah. So I'm not technologically savvy, but I will, make a request to. Okay. 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 Good. Okay. 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 Thank you. Thank you. Thank you, ma'am. I will. I will. Yes, Miss Vasaf, there is a suggestion from your classmates that I should, wear the headphone and Bluetooth, mic would also be there, and that will connect me to the, laptop, and whatever I'm, speaking, I'm going to be audible to you. Everything you are going to listen. Yeah. From next time, inshallah, I will try. I will procure a headphone as well. Well.
Thank you.
So when you were talking about the definition of human, and he asked the question like why did right? So there, and while you were giving us the answer, there was one question like which arrived in my mind, like like for also like the example which you gave, like somebody wants to go to another country that he thinks that it is his right to go to that country, and whether you should be think that whether that state has the right to take or whether the state has the right to do it. So why don't we think it or like heavy, or why don't we think it in terms of human in the like a human duty, like more than a human right? Like we are more of a right-based, right-oriented society. Like dharma, like in the Indian system, our legal framework was most of the time was duty-oriented. So why don't we at an international platform think of it on even more of a humans who are duty bound rather than
Yes, absolutely. Yeah. Well, I appreciate your intervention, Mr. Shivam. The idea is, my dear friend, if we are going to take a very comprehensive interpretation of Article 15 of the Universal Declaration of Human Rights, right to live and right to return, or right to enjoy asylum in another country, as per the mandate of Article 14 of the Universal Declaration of Human Rights. These are the two important provisions, though all the provisions are important, but in our context in which we have been deliberating, what are human rights and what are the sources of international human rights law, then, my dear friend, Article 14 empowers a human being, but at the same time, and you have rightly pointed out, it becomes the duty of the state ever since the emergence and recognition of an individual as a subject, as a what you call as a central engagement of international law. When we regard an individual as a centrality, or an individual has become integral to intellectual engagements, so far the international law is concerned, particularly that is a development which took place in the last 50 years. After adopting the Universal Declaration of Human Rights, particularly, and we are in the third decade of the 21st century. So cumulatively speaking, my dear friends, national governments have been what we call, given this kind of a understanding that it is the duty, because we are dealing with not individuals, but we are dealing with the subject matter of international law. So there is a process. There is a there is a evolutionary peregrination, I should call it. That journey is going on, and on the basis of this evolutionary journey, these dynamics are coming out that we should regard and we should extend. And that is why, if you take into account the entire international migration law and the functions as well as the contributions of International Organization for Migration, you will note the even United Nations High Commissioner for Refugees has also issued on many occasions certain important notes, multilateral notes on human migration and their reception. If you take into account the latest what we call situation of refugee migration that is taking place from Ukraine to the and they are crossing into neighborhood countries like Moldova, Slovakia, another, or Hungary, or other important what we call border states, you will also find that it is basically the idea of what we call of human rights. It is the primacy of human rights. It is the relevance of human rights. It is the significance of the human rights that is moving, and their international human rights, commitments, particularly the human rights treaty obligations, which ultimately empowered the humanity, that they should be extended. Though it is altogether a different story that we have recently witnessed, the double standards of the Western powers. We have witnessed even the racist what we call policies which have been adopted by the European nation states. Only the white skinned people from Ukraine have been given some kind of a predilection, some kind of a preference by these very governments. So these discriminatory practices are there, but the fundamental question that remains there relating to what we call Article 14 of the Universal Declaration of Human Rights, yes, it has really strengthened this idea of what we call of the primacy of humanity, because there are a problem of perception. A problem of perception is that whenever it is felt in the global North nation states that there are some important problems, there are some important issues, and they feel that the problems are occurring, problems are emerging in Canada, in United States of America, in Germany, France, and Belgium, and other European nation states. They feel, including their scholarship, particularly in the 60s, 70s, and 80s, and that particular what we call hangover in certain important quarters is still what we call persisting, and they generally feel, yes, it is a problem. It is not only affecting what we call Europe, but it is affecting everybody in the world. But that is not the true situation. European problems are not the global problems. American issues are not the global issues. That is why institutions like South Asian University have been established. Because what is required in the present what we call context for the preservation and promotion and fostering of human rights is multilateral engagement, multi-alignment approach to international issues. If Europe is suffering from climate change, then we are not responsible for that. When the senior George was the president of the United States of America, and the Rio de Janeiro conference was organized in 1992, he made a statement in that very conference, and the statement was exclusively directed towards the third world nations. I am this is a very objectionable nomenclature so far my own personal understanding is concerned. I do not address them as third world nations. No, there is no first world, there is no second world, and there is no third world. I generally address them as transforming economies. The most respectable terminology we should resort to. I am coming to you. He made this statement, and he was of the view that the developing nation states should not cut their jungles. They should not cut their forests. There should not be any kind of a deforestation. Now they are basically talking that we have exploited our own forests. We have deforested our lands. We have created the menace of climate change. We have created gaseous emissions beyond the permitted limits. We are not adopting certain important resilience measures, adaptation what we call measures, mitigation measures. We are failing the conference of parties cycles. We are not paying any kind of attention. We have what we call exacerbated the pace of what we call of the disaster driven human displacements. And now they are advocating that the third world nation states should not cut their what we call forest. And they are also what we call creating some kind of a havoc picture that if you are indulging in any kind of a reckless industrialization, deforestation, definitely you are creating problems for the seismological balance. You are going to jeopardize the entire tectonic balance of the earth. If they are using this kind of a language, and even the government of the United States of America has demanded that, and they have what we call distributed the entire world population, I mean world pollution, I should say, into different what we call fragments on the basis of industrialization index, on the basis of the human development, on the basis of what we call of advancement of the science and technology and industrialization. So as per this what we call fragmentation, it has been what we call given that India can pollute 12% out of 100, but right now India is polluting 6%. Then it was offered by the United States of America that you confine your pollution up to 6%, and rest of the 6% pollution we are ready to buy. So we would increase our pollution. That kind of a nonsensical proposals are there. It is, my dear friends, if you take into account the Paris what we call COP, the mandate of that very COP, then the subsequent one, and during these COPs, and particularly during the regime of the Donald Trump, no attention has been paid. He was of the view that the climate change is nothing, it is just a bullshit. So that kind of a line of argument a president is making so far the climate change, and during his what we call regime, the jungle fires conflagration took place in California. And right now we are witnessing all kinds of fires, whether it is Europe, Australia, United States of America, even the floods. See the how the cycle of the climate change is going on. So that is basically jeopardizing the dignity of human being. Animal rights are involved. Animal habitation that has been what we call eliminated or jeopardized. So lot of not only the human rights but the animal rights are equally the casualty of this kind of attitude. So far the climate conditions are concerned. That is why we have to, and that is why the new kind of category of people is emerging, which is known as the climatically displaced persons or migrants, so CDMs, and the climate refugees. A new class of people is emerging at international level. A unique class is there, and that requires a specific address so far the humanity is concerned. Because there are rights. Rights are not something in vacuum. There are rights which are in transition. There are rights which are present, and there are rights which must be made available even in future. So we cannot simply confine the rights to a particular understanding or a particular socket. No, beyond that we have to take into account the idea of what we call of rights. So these are the sources, my dear friends. Even a tree in a jungle or in my backyard is a source of what we call of human rights. So we should be very, very comprehensively, we have to define humanity. Humanity does not confine, or this should not be limited to the human existence alone. And that is why, my dear friends, another idea which on earlier occasion I have submitted, that a new class of what we call of rights, new class of or new categories also emerging, which is known as the rights of nature. And there are many judgments from India as well as from other important what we call jurisdictions. And I have given you an example, if you recall, the Constitution of Ecuador, where for the first time the rights of what we call of nature. In a specific form, in a specific, the Ecuadorian Constitution of 2008, that Constitution incorporates the rights of nature and its ecosystems. Yes, yes, Apurva, you wanted to say something. Then I will complete. Yeah, please. Not only the questions are allowed, but at the same time, you should also collectively give some kind of a respite to my vocal cords by making observations, offering comments, and other important dimensions. So, thank you very much for this ability. Okay, I got your entire question. This is how you spoke yesterday. No, I'm talking of your body language.
The way you speak, in the response.
Very seriously, you are making a comment that gives a different kind of an impression of my approach. You are using a very beautiful word swap, right? But the way you have delivered it, that has created a wrong impression of mine. So, anyways, we are we are just kidding. So there is no problem. Yeah, your first question is, what did you say? Yeah, third one. No, ma'am. Miss Apurva, third world is not confined. Third world is a grouping which basically or was created by three eminent international personalities. Anwar Sadat of Egypt, Marshal Tito of erstwhile Yugoslavia, and Jawaharlal Nehru of India. They came out basically this particular idea of non-alignment movement. In abbreviation, it was designated as NAM, NAM. In this particular grouping, all the Afro-Asian nation states came together. And it was the period of Cold War, when entire world was divided into two political blocks, two geostrategic blocks, two armaments blocks. One was led by United States of America, which was known as a capitalist bloc. Another bloc was again led by USSR or elsewhere USSR, a communist what we call bloc. These two ideologies were there. They were basically running the entire what we call global scenario. After the disintegration of USSR under the general secretaryship of Mikhail Gorbachev in 1991, 15 new republics emerged out of USSR, which is today known as the Eastern what we call Europe or Eastern part, and the Central Asia or Central Asian republics like Kazakhstan, Kyrgyzstan, Turkmenistan, Uzbekistan. So these, where even some of the people have also fled because of the Russian persecution in neighboring what we call countries like Afghanistan and Pakistan, Uzbeks, Hazaras. Our friend, online friend, may also enlighten and educate me on this particular development. I am talking of Ms. Wasaf Rasool. She can also offer her comments on this. But these grouping of people, how they have started as a non-alignment community, has subsequently become the most aligned community. They could not maintain the integrity, probity of this particular international reasoning, I mean grouping. So entire non-alignment movement gradually what we call lost its sheen, up to what we call during the prime ministership of Mr. late Rajiv Gandhi, some semblance of availability of NAM was there. but nobody bothers in today's what I call context, because new kind of an alignment is taking place. And these, I mean, the membership of entire non-alignment movement was not confined, rather everybody was invited in this, but it was the predominantly and prominently it was the nation states hailing from Africa continent, from Asia, and from Latin America. They have become the party to it, but now it has become obsolete, redundant, and archaic. We are having new groupings, new alliances. And recently, even the foreign minister of India has also made a statement in New York, and he came out with the idea of multi-alignment instead of non-alignment. So that is a paradigmatic shift in the foreign policy discourse of India as well, and that is also influencing the idea of what we call of the preservation and protection of human rights. So, and he was right when Mr. S. Jaishankar made this statement that the rights violations in Europe is not a global issue. Preservation of rights, preservation of sovereignty, preservation of what we call of the foreign policy doctrines are equally important for other nations, because it has been witnessed over the years that whether it is the US government or other European nation states or the European governments, whatever they have agreed on paper, whatever they have evolved, that has not been implemented in its letter and spirit. Suppose the Monroe Doctrine of United States of America, when President Monroe was there, he came out with the Monroe Doctrine. And the basic and the most fundamental element of the Monroe Doctrine, my dear friend, is that there should not be any kind of interference on the part of what we call of a particular nation states, or on the part of the United States of America. There should not be any internal interference in the internal affairs of other countries. That is the violation number one. Another, there has been some kind of an improvement instead of what we call merely confining to interventions in other countries. United States of America has adopted a very a monstrous policy, and that monstrous policy is the forced regime change policy. What happened to Iraq? What happened to other nation states? Forced regime change. It is the sovereignty. It is the will of the people, as per the two important international conventions of 1928 and 1933. I am talking of the Montevideo Convention and Havana Convention. These two important conventions have been adopted under the auspices of the League of Nations. So to what extent the mandate of these kinds of arrangements has been respected? There is no respect at all. American interest should not be the global interest. Eurocentric projects should not be what you call presented as the world projects. But this is what we have been witnessing, and that is why, my dear friends, I requested you, and I don't know whether I have shared it or not. We should try to understand international law from below, as written by Professor Gopalacharya. That is very important. And if you don't have the soft copy of this book, I will provide you with this copy. So this is how we should try to understand the idea of sources of international human rights law. And what is your second question? Rights and duties. Yes.
Takes away the right of abortion. Basically, criminalizing the system. But this, in America, is creating a duty to sustain children. How, for example, today, if a pregnant woman wants to take she might not get it because cancer keeps leading to abortion. So that creates a duty to sustain pregnancy in the scenarios where
You are making a very sweeping statement, ma'am. You have forgotten the exceptions in the top source Jackson.
I'm saying that I'm not speaking very,
Your apprehensions are correct. I appreciate.
I'm not speaking the part of judgment. Implications of it.
The implications have been placed as exceptions, ma'am. In case of threat to the life of woman or a girl, suppose rape, suppose incest, suppose what we call disease, which is having very harmful implications, which might what we call jeopardize the existential life, or there are diseases which may turn a woman's life into a vegetative existence. So in these situations, abortion or access to abortion has been allowed. Yes.
The decisions that a doctor would be making, the call that, for example, Planned Parenthood that funneling an abortion, the decision that it should be making will be surrounded by all these things. In that sense, as I another the woman named Margaret Black, who had an altercation with her co-worker, and the woman shot her boy's stomach, and she lost her fetus. And Alabama tried her. Not the other one, it is Daniel Brown State. These cases are
Yeah.
they found cases which very
Yeah.
there was a right, so there was a duty for her to prevent not getting into fight with
Yeah.
the implications of
Actually, we require for such kind of situations. Your apprehensions are correct. It's very very a challenging one, but at the same time, it is important what kind of a judicial mind is presiding over. So we require better what we call, and in such situations, I am of the view that such kind of a cases should only be what we call litigated or only be heard by the women judges. That is the requirement number one. No, because it's a very very sensitive issue. It's an extremely sensitive issue. There are issues. Suppose my wife is suffering from a disease, from a medical condition, which requires, and it has been medically suggested to her that you should go for another child. But she refused. She said, no, I'm having a son of 16 years of age, 39. And immediately after his birth, almost 8 months, this medical problem, and she is under treatment, and 3 surgeries have already been conducted in a span of what we call last 12 years. Each surgery cost me lakhs and lakhs. But she is not ready to have. And I have always been there. I am there to all her. But this problem could not be there. Now at this state, it's a mature state. It would not be appropriate, and it would not be, even now, it is not medically advised to have any child. So in such kind of situations, it is important. It is very, very important to have a greater amount of sensitivity towards female issues. Lot of complications are emerging. Even without prior to marriage, immediately after the attainment of the puberty by girls, they are facing lot of issues. Lot of problems are there. So we should be sensitive enough. It is very, very problematic to survive as a grown-up girl, and that will impact the outer society. So in such a situation, if we are allowing this kind of a right abortion, we are also witnessing some kind of a violation. Even there are girls, because of some other kinds of preferences, they are going for body. They are wrongly exercising their individual autonomy. We cannot what you call simply abandon this argument or simply reject this kind of argument. There have been. We should try to understand at the same time, though I am totally against, personally speaking, I am not at all comfortable with the Dobbs versus Jackson decision. And my writing is already there in the public domain. You can read it. What kind of a person I am, that is reflected in my writing. I have already written a blog on this. So Dobbs versus Jackson has created, or rather has done, the greatest amount of disservice to the women empowerment worldwide. Because there are certain movements which are going on for the empowerment of women, for the emancipation of women, for the restoration of their human rights, for what we call, for strengthening, so far the strengthening of the feminist movements are concerned, everything worldwide, emasculated because of this kind of, archaic judgment. But at the same time, there has to be inherent, inbuilt, what we call, amount of accountability among the girls. Because if we are talking of our body, and I'm taking you back to that very question which Mr. Shivang has asked, who is a human? What constitutes a human? What are the elements which constitutes a human being? Then it is equally important that the body, human body, should be treated. I am sounding a little bit preaching, so my preaching should be what we call rejected. What is important is that what we call integrity of your personhood, that must be what we call preserved and maintained. Because the human body is like a trust. It should not be misused. It should not be exploited. It should not be. Whatever is there, which is going to harm. Suppose my friend is here. He is very smart, a handsome guy. So he should not, because at the same time, as a human being, as a human right holder, he is also the trustee of his own body. So we are basically trustee of our own bodies. And being a trustee, we are basically talking of integrity, dignity, and everything. So this is very, very important. You have to share your giggling with me, Mr. Mr. Shiva. Yes, sir. Yeah, Mr. Sagar, you are saying something.
There is always a debate between human dignity and human rights. So, reading this, if it was written that if we keep the human rights on the path of human dignity, there cannot be any outcome of that rights, because human dignity might be something different from someone, and it has a very dynamic approach towards handling the human rights issue. So when we talk about the body integrity and all those, do we go again into the debate of human dignity?
Yeah, dignity is important because there should not be any kind of a coercion. There should not be any duress. There should not be any kind of a pressure. How you have to conduct yourself in the society, but within the four walls of the human rights premise, these are the legitimate expectations to conduct ourselves. Because the idea of source, when we are talking of sources of international human rights law, so human being is also a source of human rights. So you are the sources of human rights law. So human rights emanating, oozing out of your personality, stemming out of your personality. So how we are conducting, that is the one part. Second part, you are talking that the concept of dignity is dynamic. Yes, agreed. You have ultimately simplified my task. Because when we are talking of dignity, dignity is susceptible to more than one interpretation. It is susceptible to various multiple what you call dimensions and interpretations. What may be an element of dignity in our part of the world, there is every possibility it may not be a part of dignity in another world. Right? So how I am dressing myself, how you are dressing, what kind of a coiffure you are maintaining over your head, what kind of a sartorial statement you are making and I am making, or somebody else is making. These are the individual choices. Even there are, if you are meeting an Arab and you are meeting a Pakistani or a Central Asian or an Indian one, you will find a different kind of a dress code. I'm talking of men only, not females. So, in such a situation, so it is there. What is important is in some religions, only this much has been prescribed that the vital parts and the vital characteristics of human body should be covered. Right? It has not been, described what kind of a cloth should be there, what kind of a idea of dignity should be there. But at the same time, we have to, since you have used the word dynamic, so dynamics of dignity are what we call insurmountable, innumerable. So therefore, that really enriches the entire literature on human rights and dignity. So dignity cannot be confined within the architecture of the geopolitical understanding. What may be a dignified existence, because right to life without a dignity amounts to some kind of animal existence. That is the basic and the most fundamental understanding, and I hope you have been studying it since your graduation. So what is important is we have to have some kind of a considerable amount of dignity. And it is equally important in my understanding when we call that law is not static, law is dynamic. Same is the situation with that of the idea of international rights law or human rights perceived as dynamic rights. Human rights may also be a language of armament, but at the same time, the human rights is also the language of peace. And primarily, it is the peace which is always expressed in human rights parlance. Yes, ma'am.
I did not understand your point about how women are excusing their autonomy of. You just mentioned that it respects abortion rights.
I also wanted to ask that because I wanted you to please substantiate further on that ground of argument of body autonomy and further. Because generally, when we argue on that line, there is a tension of there is a susceptibility of being down there as patriarchal something like that.
And on the same line, sir, I would like to ask you one more question. Right? Like I completely agree with like what the point which she was making and the way you said like what is your inclination towards this whole issue. But then there's this also question which comes in like you explained very nicely that then we are living in a patriarchal society. However, when we are talking about body autonomy here, like there are then certain section of women rights activists who also want to claim some kind of like they also have some rights over it. So, what is your opinion and how do you believe that to be counter to that thought of school life? They believe they also have some sort of autonomy over them.
Yeah, please go ahead. So there should not be any reluctance. Yeah. Because you have basically contributed, and remember one thing. If you are asking questions, you are basically increasing your grades. If tomorrow you are going to do again your LLM in Cambridge or some Western higher learning institutions, so they have given 10% marks for class participation. A long back I have suggested here also that the class participation must also be there, and a sheet should also be prepared on the lines of the attendance sheet for class participation. Who have participated? Yes, they should be correctly or ticked or marked in the that very class participation attendance sheet. So it's very important. That is a very, very valuable contribution. If you are not asking questions, I am having this document of in the name of the course curriculum, right? And the question part, questions in focus, that category is also the part of it. This is the collective experience of teachers and students community. And this is a collective experience of the last 12 years, which I have placed in the form of questions in focus. So that is why you read your course structure very carefully. So for this particular portion is in concern. It is the contribution, and I am openly acknowledging the contributions which have been made by your seniors. So I am always, if you are selfish, I am equally selfish, right? If you are taking something out of me, I am also taking lot of what we call questions. And on daily basis, though I have uploaded it, I got it uploaded on the university website, but on daily basis, I am making changes in its what we call structure as well as its scheme on the basis of our class and deliberations. Yes, the question which we have here asked, and it is a common argument in all the three expressions, and that is autonomy of our body or bodily autonomy. It means there are certain important rights. Of my understanding, you got every right to differ with me. Human body or as an individual, whatever the rights I have been claiming as an individual in the society, I have been created as a human being. I have been blessed by Almighty God or my Creator. Certain important inbuilt inherent rights. Some of the rights I have acquired after my birth. Some of the rights I have, incorporated, inculcated in a very sophisticated and polished manner in my, body. There are certain important rights which have been imbibed in my human what we call structure because of the internalization of law, because of the public policy, because of morality, because of the geopolitical incentives, because of the geopolitical imperatives, because of my geographical location, because of my moral conviction, because of certain important customs, my entire body or my entire existence has been strengthened, and that has created some kind of a dynamic picture of a human personality or a particular individual personality. So if somebody has been empowered economically, somebody socially and what we call culturally enriched, because of his societal surroundings, because of parental upbringing, then he has given a faculty of reasoning how he is going to conduct and behave in the society. So he got some kind of a autonomy. Not
Sir?
only autonomy, but I would rather go to the extent of designating this kind of a human empowerment, creating some kind of a human sovereignty. I am sovereign within my own limitations as an individual, as a human being, and that is why I am saying that I am a source of law so far the human rights are concerned. I am a source of creating human rights, or the sources can be extracted out of my body, from my education, from my background, from everything, because by virtue of being a human being, I have become a source of what we call of human rights. So therefore, how I am behaving, how I am conducting, how I am what we call creating some kind of a models for others, it is a question of what we call of bodily sovereignty or bodily autonomy. What is going to be harmful for my body, what is going to be what we call detrimental to my human existence, I should save my body from those what we call menaces. If I am what we call having some kind of a iron stick and I'm touching it with that of my teeth, then it is going to be harmful for the teeth. It is going to be obnoxious. That is why we have to create a balance. When I am as a what we call human being, I am demanding from the constitution, people who are operating the constitutions of my geopolitical entity, that I need a human right to a healthy environment, because that is very much what we call going to sustain my sovereignty, my individual what we call autonomy as a human being, as a part of what we call the societal milieu. So this is how we should try to understand the whole idea of the bodily sovereignty or bodily autonomy. Same is the situation is, yes, there are certain important what we call friendships. There happens to be a boy and a girl. So there are certain important limitations on the part of both the sides. how they are going to conduct themselves in the society, how they are basically indulging in certain important interactions or high interactions, emotional interactions, psychological interactions, social interactions, political vertical exchange of views. This is how we have to create some kind of a balance. Nothing should be done that abuses or harms our body. So autonomy of this center, autonomy of this trust must also be maintained. That is the understanding. But at the level of implementation, at the level of execution, we are having different kind of parameters. We are having different kind of outlooks. How we are going, some kind, suppose there are people who do not bother about, no, my perception is wrong. Yes, I accept my perception is wrong. They are having a different kind of a yardstick to understand and to measure that this is not the manifestation of abuse of my bodily autonomy. And basic, and in my ultimate analysis, there are certain important rights of an individual over his or her body, and that makes the autonomy.
All the examples that you gave, are you saying that you believe that abortion should only be allowed when there is a threat to the body of a woman?
No.
And otherwise not?
No, that has never been my intention. I still believe the central ruling that has been delivered 49 years back in Roe versus Wade. So I still believe in that. Charity begins at home. I do not enjoy any kind of a duality in my personality. So far, my personal views are. This is something I practice even in my home. And you will find in my larger family, the girls are more educated than the boys. So this is what we believe, and my entire what we call family background believe in the empowerment of. And just to just to muster some kind of a support, just to gain some kind of a brownie point. That is not my intention. I do not want to depict or to have a rosy picture of my personality because that is not my intention. This is the reality, and this is how we should. Because what is happening? I have given you an example. 11 convicted fellows have been set at liberty on the occasion of the 75th anniversary of Indian independence. So, no, I should not use this word because it's the governmental what we call it. So it is up to the institutions. Institution of judiciary is there. Institution of council of minister is also there. Institution of the chief ministership is also there. Constitutional positions are there. One boy only of 9 years of age. Latest example, there is I'm not saying what you call, specifically I am deliberately mentioning, no. It's a chain. Every year, every day, every month you will find. And I'm what you call citing the government data. I'm not citing some private institution there or on the basis of political opinion because I'm a political person. But I believe in Aristotle that the politics is interested in me. I may not be interested in politics. Aristotle has rightly pointed. So that is there. But without any kind of reservation, as a purely within the human rights framework, we have to understand what exactly are the sources. There are sources, the sources of international law. Same kind of sources are generally invoked for the sources of international human rights law with minor modifications. But we have to look beyond it. I'm not here to again simply offer you with a traditional and conventional understanding of the sources of international human rights law. That has never been my intention. What my intention is that there are rights, there are people, there are minorities, there are LGBTQI communities, there are other communities, there are indigenous people, there are other what you call tribal peoples. Who is going to talk of those very what you call rights? They are the sources, the real sources of international human rights law. If these sources are not appreciated, then our entire deliberation remains incomplete, inadequate, and I should say, and I go up to the extent of saying our entire deliberation is going to be an obtuse what we call So we have to be very careful. And in higher education, my dear friends, higher education is nothing but the cross-fertilization of ideas. It is a cross-fertilization of not only of ideas, but it is again on the basis of our deliberations. It gives and empowers us intellectually to create new ideas. Generation of knowledge, generation of ideas. This is how we should try to understand the entire premise to what extent human rights are going to be regarded as the sources of human rights, in addition to other important what we call disciplines on the basis of interdisciplinary approaches. Yes, Maharaj Inside, you were saying something. Yeah, please, most welcome. Oh, thank you, so nice of you. Yeah, you speak a little bit loudly. Your friend is there. Miss Rasool is also there. Who?
He put a message in the chat box.
There is a collective request for the online friends. If you want to say something, you can also write in the chat box, and I will read very loudly from the chat box so that everybody should feel. I mean, the intellectual integration would be there. Do you want to say something, Miss Rasool? You can type.
Sir, yes, sir, I posted in chat box.
Okay. Yeah, Miss Wasif, she's making a point. What is the significance of religion as a source of human rights law? Very good question. I have reserved it deliberately for the week 3. Isn't it an irony that many Muslim scholars consider religion as a source of human rights law, but on the other hand, they object the right to change belief? It's a very controversial one. Miss Rasool, I immensely appreciate your intervention. We are running short of time. That is one request. I will take up my next what you call submission from these two important questions, and I will adequately address your questions. The only request is, please, instead of chat box, right now you have given me an idea, I will not forget, but I would like to request you, please, you should also make an email to me with these questions. That is my submission. I would be taking it up. Another important point, that week 3, I draw your attention, Miss Sumaya. Another important submission is that the third week has been exclusively devoted to South Asian perspectives or global South perspectives. And for that, I'm going to share requisite readings with all of you. So those, please try to study those readings, and with your own line of arguments, you should come out in the class. And right now, I am requesting Mr. Shivam, Mr. Shivang, and Maharajan. And what is your name, brother? Mr. Saad. 4 students are going to make their contributions on Monday next. And today in the night, I will share. It is going to be a research what we call presentation on the basis of your idea from an article. You have to select your own idea from 2 different articles, 2 articles. Only 2 articles would be there. Out of these 2 articles, you are going to make a presentation. Each one of you is going to make a presentation of 2 minutes. Right? So that I will share the requisite articles for you, and you are going to make a presentation. Only 2 minutes each. That is the requirement. So only almost 10 minutes. If 4 persons are there, it will consume only 10 minutes or 8 minutes. So on the basis of this, we are going to drive our entire what we call intellectual surgery of this particular week. Definitely, it is going to be very, very important one. So you should also feel well integrated so far the intellectual feelings you're concerned. Now I take your arguments, please. What is your comment? Yes, Mr. Rasool, Mr. Maharajan is making a comment.
Right under the US Constitution. The judgment has certain important implications. Example, he said that one of the example said that right to life does not have right to privacy because it does not find place in the Article 21 expressly. So then there is a possibility in future cases for the Supreme Court of India that they may say another right to free from pollution is not a fundamental right because it does not find mention in the Article 21. This kind of textualist approach one should not subscribe. They just interpreting the constitutional provisions, they should adopt some liberal approach and try to widen the meaning and enlarge the meaning around. And this is what Indian Supreme Court is doing since 1970s. And in this regard, I want to add one point that Anthony and also articulated the idea of human rights treaty as living treaty. So we should interpret whenever case concerning human rights comes before the court, we should take the meaning as on that date. I mean, when the judge is hearing the case. So, in this regard, one of beautiful article written by man professor, right to access to abortion is right to access to abortion is a right to privacy right. In that, the other points out that everything cannot be written in the black and white and in the written constitution. There are constitutional principles conventions. So
You have read the question, you have formulated the problem, and you have also answered the problem. Very good. Very good. Let me supplement your argument. I will take few seconds only. Austinian orientation of law is no more acceptable. In your words, this is known as textualism. Today, we have adopted a progressive approach towards interpretation where the harmonious construction of legislative semantics is preferred. Originalism, constitutional originalism, is always tested on the anvil of sociological interpretation. Sociological interpretation does not mean the Marxist framework of interpretation. Rather, grammatical interpretation has already moved to golden rule of interpretation. And there is a consensus, my dear friend, Mr. Maharajan, that we should not subscribe to the textuality. Yes, textual reverence is important, but we should not, confine, because one of the important argument which I dismantled in my, blog is that the American judges cannot surreptitiously shroud their argument that the American civilization does not mention it. No, it's a flawed argument. The Supreme Court of India cannot take this argument that the Article 21 does not what we call, and in the last, you have rightly pointed out, we cannot forget the dynamism. You have also, pointed it out, Mr. Sagar. We cannot what we call forget the legal dynamism, which basically facilitated by constitutional convention, constitutional evolution, and certain fundamental dynamic principles which creates coordinates of two kinds, legal coordinates and social coordinates. So we are here to reconcile these coordinates in the society to maintain this cycle of dynamism within the framework of constitutionalism of human rights. Thank you. Yes, Miss, I am conducting your attendance. Yeah, Miss Apurva, you are here. Miss Tasneem, Mr. Ojha, Miss Karishma, Miss Kathir, Mr. Lucky Singh, Mr. Maharajan, you are also there. Mr. Rakub Islam, our online friend.
Yes, sir.
Yeah, you are here. Thank you. Yeah, Miss Meenakshi Priya. Mr. Mohammed Saad, yes, you are here. Mr. Yaqub, our online friend. Yeah, he is not available. Miss Yodha, you are also here. Mr. Sagar, you are also here. Mr. Shanti Tamang. No, Shanti Tamang.
Yes, sir.
Yeah,
I am online, sir.
yeah, thank you. Miss Satakshi. Mr. Shivam, you are also here. Mr. Shivang, you are also here. Miss Tali Ganguly. Miss Vandita. Miss Vinita. Yes, Miss Wasaf, you are also here. Mr. Tohidul Islam. Mr. Naeem Hassan Talha. Miss Sumaya, you are also here.